by line, slide by slide. I don't think that does anyone much good. What I really want to do today is focus on the practical issues that we see. Our firm currently represents over 1,000 communities all throughout Florida, and we deal with a lot of these fair housing, emotional support animals, pets, all of that fun stuff. So I really want to focus on what we see every day, the issues that our boards bring to us, the issues that property managers who are really on the front lines dealing with these things. I think it's a good idea to kind of take a broad overview of how did we get here? What are we even talking about? And the main point to know is that there is federal and state fair housing laws, okay? And the Federal Fair Housing Act in Florida has one as well. What it essentially states is housing discrimination is expressly prohibited. So if you're a member of a constitutionally protected class, I'm talking about things based on race, religion, color, sex, national origin, all those things are obviously protected. And I think it goes without saying, and no one's ever had a question about this, but housing providers, which include HOAs, co-ops, and condominiums, cannot engage in discriminatory conduct regarding those protected classes. But what we're talking about today is one specific protected class, and it's the last one here, all right? Disability and disabled individuals. So that's a protected class. So how we got here today, dealing with all of these fair housing issues, is that it used to be, and again, this is my 10,000-foot view of what I'll be chatting about. It used to be that, let's say, the original declaration of condominium, or if you're an HOA, the original declaration of covenants and restrictions. If you're a co-op, the original proprietary lease or the bylaws, the original documents drafted by the original developer could have language that say the following. Article 10, no dogs allowed. Okay, even the best attorney can't argue about what that means. It means no dogs allowed. It used to be that boards knew that there was some law out there that if someone with a physical disability requested an accommodation, an exception to that no dog provision, most boards and managers knew there's some law out there that would make someone like a vision impaired person, a blind person. There was some law out there that would allow that blind person to have a seeing-eye dog. And most people were comfortable with that. There wasn't much controversy involved with that fact pattern. And the law that would require communities to allow that physically disabled person, a vision impaired person, to have that seeing-eye dog, that was the Federal Fair Housing Act that protects, disabled people, protects them from housing discrimination, and requires communities to make what's called a reasonable accommodation. So you're making an accommodation, an exception to that no dog rule. What's happened over the years, okay, is the definition of who's disabled has broadened drastically. So now it's not just physical disabilities, but it's emotional ones. It's impairments that you or I cannot see, all right? And I'll go to a slide in a second that has a long laundry list of those things. Before I go too much farther, I think it is important to just point out, okay, that there are two federal laws that oftentimes people refer to. One of them is on the far right. That's the Fair Housing Act. That's what applies to residential communities. That's a federal law. Again, Florida has its own version as well. But there's also another federal law. It's the ADA, the Americans with Disabilities Act. And a lot of people refer to that as well. However, that's really not accurate because the ADA only applies to places of public accommodation, such places as a restaurant, the movies, an airplane, the mall, okay? The ADA typically does not apply to private residential communities that are not open to the general population, okay? So if someone references the ADA talking about emotional support animals, that would be an inaccurate statement, okay? So emotional support animals and the ADA talking about private residential communities, the ADA does not apply. I just thought I would point that out. But going back to how we got here, as I mentioned, the term disability or handicap, it now encompasses both. It's a physical or a mental impairment, okay? Now, the mental impairment, this is I guess it's a laundry list of things. And this is what attorneys like to use the phrase including but not limited to, right? So this is not an exhaustive list. This does not include every single impairment that could be considered an emotional one, okay? For instance, we know such things as anxiety disorders, stress disorders, okay, are do constitute a emotional or a mental disability that's protected under these fair housing laws, okay? Now, someone could be disabled, and that disability, part of that definition means that one of the disabled person's major life activities needs to be impacted, okay? So it's not just enough that someone may be disabled. That person also, in order for this person to get a reasonable accommodation to that no dog rule, the person must have one of his or her major life activities being impacted. And those things are most common sense things. It's right on your slide here. Such things as caring for oneself, hearing, speaking, breathing, working, learning, seeing. It's really anything you could possibly think of as a major life activity. Okay, so that's a little bit of the background. That's sort of the 10,000-foot view of how we got there, right? That the definition of who's disabled has been expanded to include emotional and mental issues. So now under the federal and state fair housing laws, in the same way that a vision impaired person has always been allowed to have his or her seeing eye dog, even in a community that restricts dogs, in the same way, someone who has an emotional or a mental disability is able to have their assistance animal to provide them the same type of assistance that a vision impaired dog would, okay? And obviously, the magic phrase you hear is a reasonable accommodation, basically a fancy phrase meaning an exception, a waiver, a variance, right? You're allowing this accommodation to what your pet restrictions are. The actual request, okay, and I think this is important to note. And by the way, I will talk about the new Florida statute. It's in chapter 760 of the Florida statutes that was adopted in July of 2020, which codifies and includes lots of these things, but I'll definitely touch base on that. From a practical perspective, the way that it works is you'll get a request from a disabled person for the board to make a reasonable accommodation. It does not need to be in writing. It can be verbal, and it does not need to come from the disabled person themselves. It can come from the spouse or partner of that disabled person. It can come from a real estate agent if the request is being made in conjunction with a sale, all right? If you get a request, if you take nothing from my talk today, I want you to take this point. if you get a request, even if it's verbal, from someone for someone making a reasonable accommodation, if the disability is not obvious, right? We're not talking about a vision impaired person with a seeing eye dog. If the disability is not obvious, almost always your initial response to that request should be, thank you so much. We will review this and get back to you. Okay. Almost always, you should not immediately approve it without reviewing what the request actually says. So you don't need to approve it that day. You obviously have the ability to do some due diligence and review the nature of what's being asked. And you almost always should never reject it right when it's made. So in our view, the most appropriate response, the most appropriate immediate response is, thank you. This shall confirm receipt of your request. We will review and get back to you. All right. Now, you have an obligation, and this is mentioned in this slide, to provide a prompt response. I can't give you a magic number of what that prompt response is. All right. We know if we're dealing with a real estate transaction, most real estate professionals, and I love them, I have members of my family that are in that field, but most real estate professionals, they want the deal done when? An hour ago, right? So you might have pressure to make this decision immediately. There's no obligation to provide it immediately. Your obligation is to provide it promptly, okay? Now, do I think 5 days, 10 days, 14 days? Certainly, unless there's extenuating circumstances, 30 days in our view is the most time that should be required for the association to provide its substantive response. That response might be, we need the following additional information, and I'll talk about what you're allowed to ask for. But the key thing is no undue delays, because there's been court cases out there that have held that a board simply sitting on its hands and not responding, that's equivalent to an express denial, okay? It's viewed as an implicit rejection. And you don't want to give any implicit rejections. You want to engage what the fair housing agencies call a meaningful interaction between the requesting party and you all. So you want to have dialogue, and it wants to be prompt, all right? Now, regarding association procedures, especially if you get a verbal request, we've assisted many clients who have adopted policies, written policies, to deal with a reasonable accommodation request, including a policy to require certain things. For instance, a current vet certificate showing that all the shots are up to date. That's certainly valid. You could certainly require a dog, a form that has a photo of the dog and identifies the breed, the weight, just some information about that dog. If it's a verbal request and or you have not received any documentation from a health professional to support the disability related need of that animal, you certainly can have a policy that has a suggested form that a disabled person can complete, to have that his or her health professional can fill out. It's important to note, though, if you get a letter from a doctor or a health professional from the requesting party, you want to review the four corners of what that submitted letter states. You don't want to ignore it and say you have to fill out our specific health care form, all right? That would be likely viewed as impermissible by the fair housing agencies. So if you get a letter from a healthcare provider, you should review that. Certainly get in touch with your association attorney to assist to see whether what you have already received is compliant or not If it's not, you can certainly request additional information. All right. Now, some important things I want to point out about the animal itself and the way the fair housing laws work. Okay. And we use the phrase an assistance animal. That's the phrase that the fair housing agencies use. An assistance animal includes an emotional support animal. Okay. What the fair housing agencies say is a properly documented emotional support animal does not need to be certified, does not need to be trained. What the fair housing laws and the fair housing agencies say is that the wonderfully intrinsic nature of that dog, that in and of itself is enough emotional support to assist that disabled individual. Okay. So in theory, if you get a letter from a health professional that confirms the following three things: that the person is disabled, again, that includes mental issues. So the first thing, that the person is disabled, that person's disability impacts a major life activity. We talked about that list earlier. And that the specific dog will provide emotional support to alleviate the symptoms and allow that person the equal opportunity to use their home. Those three things are enough under the fair housing laws to require a board to approve the request for the emotional support animal. So I'm kind of giving you the answer now, right? It's only three things. Is the person disabled? You cannot ask for a specific diagnosis, okay? Just confirmation. Is the person disabled? Does that disability impact a major life function? And will the animal provide emotional support? If the letter from the health care professional checks off those three things, the fair housing agencies say you have to allow that animal. So there's lots of healthcare providers out there that are in tune to these requirements. And we're seeing more and more letters with those magical words, those magical three things. And much to the chagrin of some of our clients, our opinion is if the letter meets those magical three things, you're going to have to approve it. And if you don't, the risk is a fair housing discrimination claim. And I'll talk about that in a moment. Okay. Now, just because we've gone through the overview of how we got here, we've gone through the specific request, again, doesn't need to be certified. The emotional support animal doesn't need to be certified. No training. I should also point out, you can't enforce breed restrictions, okay? So a properly documented assistance animal can be any breed. You can't enforce size restrictions either. So just because your documents say, dogs can't be more than 30 pounds, if you have a properly documented assistance animal that's 35 pounds, you can't enforce that weight limit against that properly documented emotional support animal. So having said all that, usually we get clients say, well, is there anything we can adopt to restrict the behavior of this assistance animal? And the answer is yes. You can adopt rules regarding what I call the conduct of the animal. What do I mean? Such things as the animal must be on a controlled leash at all times. Such things as the owner of the animal has to kindly clean up the waste from the animal. Such things as the animal can't be attacking other owners, attacking other animals. Okay, so rules regarding the conduct. It can't be unreasonably barking at all hours of the day and night. All right, those types of conduct rules can be adopted by the board and can be enforced against even an emotional support animal. We obviously suggest that perhaps the first notice you send to an owner, if their animal has violated some of these conduct rules, we certainly suggest that maybe the first letter is a little bit softer. Okay, it's not your standard formulaic violation. You want to, certainly acknowledge that the board's aware that the person has a approved emotional support animal. However, just because it's an emotional support animal does not mean that it gets to roam the community without being on a proper restraint. Doesn't mean that it gets to go to the bathroom wherever it wants without it being cleaned up. Doesn't mean it gets to attack and engage in that type of stuff. Okay. Again, this slide here goes to evaluating the actual request, and it's really just confirming those three things. Is the person disabled? Is there a major life activity being impacted by that? And does the animal provide the emotional support? Again, you don't want to unreasonably delay responding, okay? If it's questionable and you need to get your attorney involved, we certainly think that the maximum time is around 30 days, but that doesn't mean you should be waiting 29 just because you think that you can. You should timely respond and make sure you're engaging with the person making the request. All right. Again, I think it's important to point out that what I'm talking about today is when the disability is not obvious, okay? If you have a vision impaired person, that's obvious, and you're not going to be requesting anything. You just need to accept their seeing eye dog. Also, at the bottom here, I want to point this out, okay? Right there, where this slide, okay, talks about the letter doesn't need to come from an MD, okay? It doesn't need to be a medical doctor. It can be a health professional. It can be a social worker, a mental health professional, some professional that's familiar, especially if we're talking about emotional support and a mental issue, someone familiar with the mental condition of that individual, all right? So this guidance that we're sharing, this guidance is coming from the Department of Justice and coming from HUD, which is the federal agency that deals with housing discrimination complaints. Oh, pardon me. Okay. Again, just to stress who can provide the documentation, someone who's familiar with the mental health, okay? It does not need to be an MD. It can be a social worker or other mental health professionals. We get asked a lot about, well, what if this dog is a dangerous breed? I talked about breeds a bit. And again, under the fair housing laws, I know when I'm very conscious of, as I go through this, sometimes I'm the bearer of quote unquote bad news, telling you all what you cannot do. But it's very important to be aware of these things. So we get asked a lot, well, this dog's a dangerous dog. And the way the fair housing laws work is, again, you can't just have a blanket breed restriction against an emotional support animal. The only way you would be able to deny that dog based on whether it's dangerous or not is it would need to be based on an individualized assessment of that specific animal. We'll call that dog Spot. It would have to be based on, is there documentation that Spot, specifically Spot, has engaged in dangerous conduct previously? For instance, if you have an animal control report that shows that Spot attacked a dog previously, that could be a factor that the board could use to say, we're not allowing Spot in. But it can't be based on speculation or fear on the type of harm that a particular breed may do. It's got to be based on the individual dog. And I think it's important to make sure you're aware of that. All right. Couple other brief points. Then I want to talk about the new Florida statute. And then I want to get to all of the questions that you all may have. Another issue, again, me being the bearer of bad news, is the effect on pets. Let's say your documents don't prohibit animals, but say you're only allowed a maximum of 2. If someone has a properly documented emotional support animal, which would be the 3rd dog, that properly documented emotional support animal does not count towards that calculation. So in theory, someone could have 2 pet dogs and a 3rd emotional support dog. Now, if this is a fact pattern you're faced with, that's not to say that your counsel can assist you with perhaps inquiring with the requesting party, perhaps why the 2 existing dogs wouldn't provide that type of emotional support, and to really try to hone in whether there's a bona fide disability related need for that 3rd animal. But just know, generally speaking, there is no effect on the number of pets. Also, and I was a little bit remiss, I waited about half an hour to give my very important attorney disclaimer, which is what we're talking about here today. This is general education, okay? This is not to be construed as particular legal advice for your board, for your community. So it would not be proper if you're on your board to go back to your other board members today and say, I met with an attorney, I got an opinion, we can do the following things. That would not be proper. A lot of these fair housing issues do need to be evaluated on a case-by-case way. They are fact specific. So if you have a particular question, absolutely, our strong recommendation is you should be contacting your current association attorney. Even for our current clients out there, if our firm is your current attorney, please do contact us if you have a particular question. All right. So now we gave sort of the 10,000 foot overview of how we got here. We got into a little bit of the mechanics of the particular request, what you're allowed to ask for. Now I want to talk about, and this isn't to scare you all, but what happens if there is a violation of the fair housing laws, okay? The main thing to know is it does not cost anybody anything to file a fair housing discrimination claim. Every county, Miami-Dade, Broward, Palm Beach, and the other counties in Florida, they have their own local fair housing agency, their own local fair housing office. And oftentimes, even if an owner contacts HUD, which is the federal agency that handles discrimination complaints, HUD and the local county fair housing office, they'll have a working relationship agreement where HUD will oftentimes refer discrimination complaints to the local fair housing agency. And it doesn't cost anyone to file. And what will happen is, let's call the owner John Smith. John Smith will file a discrimination complaint against the condominium. They'll often sometimes name the manager or name a board member, whoever, and they'll claim that they suffered housing discrimination for the failure of the association to make a reasonable accommodation to allow that disabled person the equal opportunity to use their home by having this animal there. The association will get a very official, formal-looking complaint letter, which requires the association to respond. You're going to have to get your attorney involved. That costs money, obviously. Hopefully, the Fair Housing Agency will come back with a finding of no reasonable cause that the association engaged in discrimination. But that doesn't always happen. And sometimes the best intentioned boards, someone somewhere may have sent an email that contained language that might have inadvertently run afoul of the fair housing laws. Okay. So oftentimes, the Fair Housing Agency will offer the association the opportunity to reach an agreement, some conciliation settlement between the parties that may include the association paying a fine or going to some education. The bottom line is you don't want to be involved with a formal fair housing discrimination, a fair housing complaint. If the complaint doesn't get resolved, it could actually go to federal court. And we provided some information in your outline you can read over at your own convenience. This is fairly rare, but it's something that you should be made aware of. Before I jump to the Florida statute, I wanted to point out that we included at the back of your outline some case law, because a lot of what we're sharing here today, a lot of the guidance and opinions we provide our clients is based on case law, based on what this precedential value is of these prior judicial holdings, okay, which have shaped this area of the law. Some of the cases, the association prevailed and led to what's now the widespread opinion of most practitioners in the field that you're certainly able to request documentation from a qualified healthcare professional that that person needs an emotional support animal. You don't need to just take their word for it. And that ability is based on some of these holdings, okay? There's other cases where the association did not prevail. And there's some pretty egregious facts in where board members really went wild on what they were trying to ask for. So I think it's a good idea to review these cases. There's lots of interesting information there. What I want to share before I get to the questions is the new Florida statute, okay, which a lot of you, hopefully, if you haven't been sent this, will be sent this. But this is a new Florida statute, section 760.27. It was effective July 1 of 2020, okay, so almost a year ago. Most of the new law basically codifies, just refers to what the federal fair housing laws say. So a lot of it isn't brand new stuff in this area, but it's certainly good to see it in the Florida statutes, okay? A couple things that I want to point out to you, and actually I'm going to share the actual legislation so you all can read it with me, okay? This is the actual 760.27, and I think it's important. Let me just point out a couple of hot button things that I want you all to see. All right. You would think I would get this pen down by now. All right. There we go. Right there. This last part here, it's in subsection 2, okay? And the bottom of this says, okay, a person with a disability-related need, okay, must be allowed to keep such animal. And the main part I want to focus is the last part. And such person may not be required to pay extra compensation for such animal. All right, so I just wanted to highlight that you cannot charge an owner a fee to have his or her emotional support animal, okay? I know we've gotten questions about that. Also, a key thing that I wanted to point out is this part here, and this is paragraph 4, all right? This is new, and it's important for you all to know that if the healthcare professional is licensed out of the state of Florida, okay, they're licensed in a different state, that professional must have provided in-person care to that disabled individual, okay? So if you're licensed out of state, this new law says that person must have provided in-person care. If they're licensed in Florida, there is no in-person care requirement, all right? But I think it's important to be aware of this new language in the Florida statutes. Another important thing, which I want you all to be certainly aware of, is number 2, right here, okay? Number 2D, as in dog, okay? Number 2D says, if a person requests to keep more than one emotional support animal, request information regarding the specific need for each animal. What that means, what this paragraph is talking about is the association is allowed to request information regarding the need for each animal. We've seen this happen where our boards will get a request from someone that says, I need 2. One's not enough. I need 2 emotional support animals. And this new law clarifies that the association is entitled to request documentation, information that documents the specific need for each animal. Okay, so that's important. I'll also point out subparagraph E, certainly, which I talked about earlier, but the association is certainly entitled to request that all the vaccinations and all the shots of the dog are up to date. Okay, another key point that I want to talk about, and again, this isn't new, but it's important to know that the Florida statutes now has this, is subparagraph 3A at the very bottom here. All right, 3A. Here, this says that a housing provider, which means an association, may not request the diagnosis or the severity of whatever that disability is. All right. So I talked about that earlier, but it's good to see that that's in this new law. The last 2 things I just want to touch base on is subparagraph C here. Okay, right here. Any sort of registration, we know there's internet websites you pay, I think the price has gone up, you pay $49, you get a very fancy looking certificate that says my dog's a certified emotional support animal. We always knew, but it's good to see in the new law that any registration obtained from the internet, that in and of itself is not sufficient to force the association to approve that. All right. And the last thing I just wanted to touch base on, keep on making the same mistake, is the very last page here. Oh, there we go. It's page 14 of 15. And again, this is in the 1-page handout that you all got. But at the bottom of the page here, it was added, it's a new section 817.265 of the Florida statutes. This makes it a crime, a misdemeanor, okay? If someone knowingly and willfully misrepresents that someone needs an emotional support animal, okay? This is to protect, really a healthcare professional. If they engage in fraud, it's a crime. Now, proof is always tough, and that's a whole other ball of wax, but just know there is language in the Florida statute that now states specifically that if someone submits false or fraudulent proof, it is now a crime. All right, so that's the new, again, that's the new section 760 of the Florida statutes, and a lot of that
hang tight. We see him logging back on. Must have had a little technical glitch there.
Hey, Jeff, can you hear me now or no?
Yeah, we can hear you, and I can see you as well.
Okay, yeah, I don't know what just happened. It just said Zoom suddenly crashed. That's exactly what it said. So I'm not smart enough to understand why that happened. There we go.
There we go.
All right, we're back. Anyways, I was just saying that new language in 760 of the Florida statutes that's in the materials that you all have. All right, I would like to take any questions that we all have. All right. If you did type in your question, feel free to shoot it out again, just to make sure we get to all of them. I did get a good question about, does in-person care, does that include someone doing telehealth? Someone seeing a medical provider maybe over Zoom. The Florida statutes do have specific telehealth requirements. So it is possible that a telehealth provider, if that person's, if they meet the requirements for telehealth, it's likely that would constitute in-person care. But if you have a specific question about that, definitely get with your association's counsel. We had a great question about where does the emotional support animal, where are they allowed to be? Let me just fix my screen real quick. And under the fair housing laws, a properly documented emotional support animal can be anywhere that the disabled person's allowed to be, okay? The only exceptions are inside the pool itself, or let's say you have a kitchen in your clubhouse and there's food being made, right? But those two limited exceptions, the animal is allowed to be wherever the disabled owner is allowed to be. Now, you can certainly designate an area where the animal must go to relieve itself. But if there's a common area, if there's a place to sit in the middle of the common areas, that person's allowed to have their emotional support animal there with them. I had a really good question about the certificates online. Again, those in and of itself are not sufficient for the association to approve it. That does not mean, however, that online certificate constitutes fraud. Okay, fraud is a higher level of proof. It just means that you don't need to accept it and you have the ability to request additional documentation, but it wouldn't be on the face of it fraud. All right, let me take some more questions. These are really great questions and I appreciate that. We got a great question about what if my friend who comes to hang out with me at my condo is an invitee, a guest. Are guests allowed to have emotional support animals? And the short answer is yes, the fair housing laws apply to everyone. Practically speaking, if a guest, the first time that guest comes to your community, they might not know about your animal rules. So we always say practically guests get what I call a one-time free pass, right? They're allowed to have their dog that one time, but you should follow up with that owner to let the owner know that before that guest brings that dog, they need to make sure, if they're claiming it's an emotional support animal, you need to make sure that your guest provides the proper documentation for that animal. We had a question about the fees. Again, if your documents require someone who has a pet to pay a fee, a pet is not an emotional support animal. So if you have proper authority to charge a pet fee, I'm not suggesting that you have to stop that. What I'm suggesting is you cannot require an emotional support animal owner to pay that fee. So no money is involved at all for an owner to have an emotional support animal. But if it's not an emotional support animal, if your documents allow a dog, then certainly if your documents support a pet fee, that absolutely could be fine. All right, we talked about guests. All right, we got the famous question. I was sort of waiting for this question. I think it's a great one. The question is as follows. What about the owners that bought their unit in a no dog building in reliance on that? And what if that owner has an allergy to animals? Why should that allergic owner, why are their needs put below, in theory, an owner who has an emotional support dog? So what we're talking about is really competing disabilities. On one hand, an owner that may have an allergy disorder. On the other hand, an owner that may very well have a bona fide emotional support dog. What do we do with that? We pose that exact question to representatives from HUD. We've attended lots of different, education talks, and we've been on panels, and we pose that exact question. And the response we got from HUD basically was, we don't know. Now, they went into depth about how you need to evaluate both. The bottom line is, if someone claims that they have an allergy disorder, they're claiming they're disabled in the same way that someone who has an emotional disability is claiming that. So the individual with an allergy disorder should absolutely be requested to submit documentation from their healthcare professional that confirms that they have an allergy disorder that impacts a major life activity, and that the presence of a dog will exacerbate and will harm them. If both parties properly document via their healthcare providers that they have these competing disabilities, then the board needs to try to make reasonable accommodations for both of them. What does that mean? Then that means they need to work together. So if they're in the clubhouse and the dog happens to be there, perhaps the dog owner sits in the back and the allergy owner sits in the front. Perhaps if the dog owner is on the elevator, the allergy owner waits to use it. It's not a perfect answer at all. I know that. And there's really no perfect, way to deal with competing disabilities. And we're not aware of any case law in Florida that has touched on this. We're aware of one case out of Iowa, and you can even look this case up, but it's an Iowa case dealing with competing disabilities. And the rationale on that one case, which again isn't binding precedent down here, but the rationale in that one case seems to indicate that if the allergy owner was there first and they have a properly documented from their healthcare provider, that could be a basis for the board to turn down that emotional support dog. It's far from a slam dunk. It's a lot of uncertainty. The law really is unresolved. So you want to get with your attorney if you're dealing with truly bona fide competing disabilities. All right. We got a question about are ESAs allowed in the pool area? As I said, the pool deck is typically fine. They're allowed to be with the owner wherever the owner's allowed to be. I think inside the actual pool is a little bit of a different story, and I think the board could certainly restrict that. But if the dog is at the pool deck and the dog's on a proper leash restraint, again, it's allowed to be with the owner wherever the owner is. In our experience, practically, the problems are usually with the animal's owner, right? It's really not with the animal itself. And most people, if they do have an emotional support animal, it's certainly not causing any big disturbance out there. All right. We got another question along the same lines. Where can the emotional support animal go? Again, anywhere that the owner is allowed to go, that dog's allowed to be there, with the small exceptions with inside the actual pool itself, or perhaps in a common area where there's food being served. But outside of those limited exceptions, they can be anywhere. Now, you can designate a reasonable location where the dog must relieve itself and must go to the bathroom in this certain area. That's fine, but it wouldn't be appropriate to say the emotional support animal is not allowed to be in a certain area at all. That would most likely lead to a successful discrimination claim. We get asked sometimes a lot. Again, I'm talking about mostly about dogs. That's what we see the most. But other type of animals that could potentially qualify, we've seen emotional support: dogs, cats, a rabbit, a bird. We always get asked a lot. There's going to be snakes and monkeys and peacocks and all these exotic animals. In our experience, practically, that's extremely rare. So, I always say kind of cross that bridge when it comes. I would say 99.9% of the requests we see are dogs with maybe a cat or a bird or maybe a rabbit thrown in there. Those all could qualify for emotional support animals. On the ADA side of things, which again is the federal law that applies to places of public accommodation, there's certainly rules regarding, you're only talking about service dogs, not other types of animals. All right, can we post photos of the emotional support animals? Let me address the full question. The question is, can we post photos of the approved emotional support animals so our owners can know which dogs are there? I would certainly prefer and recommend that you get the approval of the owner to post that dog. I wouldn't do it without their express written approval. You could certainly request the dog to wear a identification tag that it's an approved emotional support animal, but I'm not comfortable under the Fair Housing Law saying you can make it a mandatory requirement. And I'm not comfortable under the Fair Housing Laws to say you can post the photo of the animal if the animal's owner objects to that. So it would be my view to refrain from that. We got another question regarding, does the letter from the health professional expire? That's a great question. The easy answer is no. Once in a while, we'll see on the letter itself, it'll say that this letter is only valid through a certain date. Certainly, if the letter says that, then that letter expires. What we do tell clients, though, is if the disability is one of a temporary nature, it's not a permanent one, I think it's reasonable to request updated information from the healthcare professional every so often. Okay, I don't have a perfect number of how often that is. I'm most comfortable, I think every 2 years is reasonable. Clients say, what about every year? I say there's no case law out there. The fair housing agencies don't give us clear guidance on that. I would prefer every 2 years. Why risk it? But could you ask for updated information? I do think that's within the authority of the board for temporary conditions. All right. We got a question about, can we include the wording from the new Florida law specifically regarding the new crime in 817? Sure. I don't think there's any issue with simply copy and pasting what the Florida statute says to make sure owners know that obviously there can't be any fraudulent request. We got another great question about what's the best process to remove an emotional support animal that's causing a problem. All right. They're attacking others. They're barking at all hours of the day and night. They're roaming the common areas without a proper restraint. My first answer is get with your association's attorney. I'm not going to kid you and tell you it's an easy process. It's not. To get rid of a properly documented emotional support animal, you need significant evidence of what the violations are. Okay, you need people with firsthand knowledge who are willing to sign affidavits to attest to the improper conduct that the dog has committed. Certainly, if there's any police reports or animal control reports, you want to build your case. You want to make it so clear to the arbitrator or the judge of what a significant nuisance this animal is, that it would be unreasonable to keep the animal there. Okay, so is it possible? Yes, we've assisted clients with that process, but a lot of the legwork, a lot of the homework, it's incumbent upon the board and the community to certainly make sure that you have enough documentation there. All right. Okay. Certainly, people can have more than one emotional support animal. If that emotional support animal passes away, if they still have a need for that animal, it's not like they just get one animal for their entire existence there. So they could certainly have more than one. All right. We got a question about being on a controlled leash restraint. And we had a very specific question about the person's individual condition precludes them from holding that type of leash restraint. That's a very particular question that you need to get with your association's counsel to make sure they best guide you to ensure that the needs of the other owners, so this animal's not roaming free, are also balanced with the physical limitations of that individual. So make sure you get with your association's attorney on that. All right. We had a question about banning breeds in general. If we're not talking about emotional support animals, you could amend your declaration. It wouldn't be enough for just a board rule, but you could certainly present an amendment to the owners for them to approve, to say certain breeds are not allowed. But remember, you can't enforce that breed restriction against a properly documented emotional support animal. Okay, we're getting very specific questions about the timing of a particular application where a tenant had the dog for a long period of time and they just got the doctor's note at the very end of the application process. You're going to want to get with your association's counsel on that specific fact pattern. Again, this is more for general information. I can't give specific guidance on these very case by case things. All right. Okay. All right. We got questions on specific cases where animals can be anywhere the owner is allowed. I suggest you can contact your local fair housing agency. They're the agency that will review a fair housing discrimination complaint, and they'll share with you exactly their views on that. Okay. I want to just touch briefly. I didn't go into it too far because it's not as common, but we're talking about assistance animals and emotional support animals. There are what's called quote unquote service animals. That phrase gets used improperly, but a service animal would be a dog, and it's a dog that's specifically trained for a particular disability. Okay. If you get a request for a service animal that's been trained, okay, that is a distinction from an emotional support animal. And a service animal, you want to be careful on what you ask for, especially typically the disability will be obvious. All right. Regarding requiring the emotional support animals to wear some sort of identifying tag or vest, you can request it. I do not like requiring it, making it a mandatory requirement for them to wear it. I think that can be problematic. All right. We've got a lot of great questions. I really want to thank you all. Again, we have questions about taking the dog to the movies or the mall. This is limited to condominiums, HOAs, and co-ops. If you have specific questions regarding your community, the amenities that you have, where the animal is allowed to be, you need to contact your attorney to make sure that you have valid rules in place. I don't want you prohibiting the dog from being somewhere that the dog is allowed to be. You could certainly run into a case where you will have a discrimination claim. Again, regarding ID tags, I've gotten about 10 questions on this. You can request it. In my view, that's no problem. I would not make it a mandatory requirement to say, we're not going to approve your emotional support animal unless you wear this vest or you wear this tag. I think that could be problematic. I already answered the question about updated medical letters. All right. I really appreciate all of these questions. Again, the dog is not permitted to be barking unreasonably at all hours of the day and night. You might want to send a softer violation notice to address that. All right, we got a great question about what does reasonable mean? Well, that's the famous question. That's what attorneys argue about every day. The reasonableness standard, you want to think about it as what would an ordinarily prudent person do if they were presented with the same facts. Now, of course, you could line up 100 people and 50 might say a ordinarily prudent person would act a certain way, and the other 50 would say the other 50 would say that person would act another way. That's why it's important that you consult with your licensed professionals about these things. If push comes to shove, I certainly think erring on the side of caution is a positive thing. All right. I got a question about, listen, if you have animal rules, of course you can, and a new owner brings a dog, okay, you could certainly request that person to make to supply information from their healthcare professional. If you want to include in your application for all owners, whether they need any accommodation or not, that's one option available as well. There isn't any law that precludes that. Again, you cannot apply size requirements to a properly documented emotional support animal. We've got that question in 6 varying ways. You can ask it in 6 different ways and the answer will be the exact same. All right. Yes, you absolutely can require that the emotional support animal has all of their shots updated. I've said this a few times now. We got asked a very good question that the husband had the emotional support animal. The husband passes away. Now the wife is claiming it's her emotional support animal. You absolutely have the ability to request or to require, I should say, that wife to submit letter from her medical provider establishing that she now has the disability related need for that animal. We got a question is, can the association get sued if we approve an applicant with 2 emotional support dogs? Can the association get sued? Anyone can get sued for anything at any time. It doesn't mean that there's merit to that claim. But the bottom line is the federal and state fair housing laws, they supersede what your governing documents say. So if someone has a properly documented request and the dog's documented, in my opinion, an owner who's upset that that emotional support animal is there would not have a successful claim. Could they still try to file suit? Of course, but I think the association would have a very strong defense to that. All right. You all were wonderful. I want to thank you all again. You asked wonderful questions. A lot of them that I did not answer out loud are very fact specific regarding specific areas of your particular community. You need to get with your association's attorney on that. I believe Jeff did send a link for the survey. I really can't stress how much it means to us if you do take the time to fill that out. We read every single one, and we really appreciate any constructive feedback that you all have. You loved it. Maybe you didn't love it. And if you didn't love it, tell us why. I'm always striving to improve in what I do. The firm's always striving to improve in the type of free education courses we all give. I think it's a wonderful opportunity to get some of your questions addressed. Really, I thank you all again. Again, Jeff just posted the link in the, I think it's in the
chat area. And thanks for reminding everybody, Andrew. Great job. It's the same exact link that will appear when we end the feed, but we like to put it into the chat because some of you might have pop-ups disabled, may not see the link and or the window that pops up. And in addition, you'll get a reminder email, to a follow-up email, everybody that attended today, tomorrow at about noon Eastern time. So for anybody on the phone who will not see this link now, keep an eye out for the email tomorrow for this evaluation, because we need this for your CAM credit for all of our licensed CAMs here today. So that'll be, and be sure to keep tabs on your spam and junk folders. Put the KBR email address into your contact list so that all of our emails show up in your regular inbox. Andrew.
Awesome. Great. Well, again, thank you all. Please check our site online, kbrlegal.com. Get on our email list. We have lots of upcoming courses, lots of exciting topics, Zooms, presentations, all sorts of stuff. So again, thank you all, and hopefully we'll see you all soon.